estate planning and probate law, business law, and contractual law. So basically anything involving a contract, as long as it doesn't land me in court with litigation. Before I start with talking about estate planning, let me tell you a little story. There was a lady who came into my office. Her husband had recently died. And his major assets were a house that was in his sole name. He owned that before they got married 20 years ago. And some life insurance. It was like a $500,000 life insurance policy that would pay out upon his death. He had a prior wife that he divorced and a daughter from that prior marriage that he was totally estranged from. So they hadn't spoken for 20 years. The lady came into our office. She was expecting to get the house outright and the insurance proceeds and live happily ever after, but he did not have a will. And when you don't have a will, we have to look at the North Carolina General Statutes because it provides a will for you. Excuse me. Yeah.
Good morning, everyone.
Okay. We need a bigger room.
That's good.
But the will that the North Carolina General Statutes provide for you might not be the one you want. So we had to look at it in this case and see what it provided. And it provided, if you die and you have a spouse and a child and you own real estate in your own name, rather than that real estate all going to the spouse, it will be half owned by the spouse and half owned by the child. So this lady suddenly found her home being half owned by her estranged stepdaughter. To make matters worse, that insurance policy, when the guy divorced his first wife, he never removed her name off the beneficiary designation. So that paid to her. They could have avoided this with a little bit of estate planning. So that usually gets people interested in estate planning when I tell that story. So with that in mind, then let's first talk about taxable estates. You can pass any amount of money to your spouse during your life or at your death by your will, tax-free. So there are no taxes on the money you pass to your spouse. You can currently pass up to $12,950,000 to other people, tax-free. So most people don't have taxable estates. That number is expected to drop at the beginning of 2026, and it's going to be around $6.5 million. But even then, you will be able to pass $6.5 million worth of assets on to other people without any taxes. So again, most people don't have a tax issue with their estates. Instead, they just really need to worry about their estate planning documents and providing for themselves during their lives and then efficiently transferring their assets to their heirs upon their death. And so with that in mind, there are basically 5 documents you really want to worry about. A will, trusts maybe, beneficiary designations and assets that pass by survivorship rights, durable powers of attorney, and healthcare powers of attorney. And we're just following this outline. I mean, I'm just following it. If you want to look at it later or follow along, it's up to you. But this is pretty much an outline of what I'm saying, so you don't have to feel compelled to take notes if any of you want to. So what's the purpose of the will? A will simply designates who gets your property when you die. It deals with passage of property at one point in time, when you die. If you care about what happens to your property when you die, you need a will. As I've already mentioned, if you don't have one, North Carolina General Statutes provide one for you, but it may not be the one you want. So if you care, you need a will. So what do you get to do with a will? Well, the first thing you do is you select who gets your property when you die. And it's up to you. You can leave anyone out of your will, you can include anyone in your will, you can leave property to entities or charities, with one exception. If you completely cut your spouse out of your will, the statutes provide ways for your spouse to reach back in and get assets out of your estate. And it will depend on how long you've been married to your spouse. Newlyweds, it's 15% of your assets. People who've been married at least 15 years, it's 50%. So if you cut your spouse out beyond that point, so if you've been married for 15 years and you only give them 25%, they can use a statutory provision to get another 25% out of your estate. But they don't have to do this, and you can defeat this through certain ways. A prenuptial agreement, postnuptial agreement where they waive this right. You can leave them sufficient assets so it's not an issue, or they can just elect not to do this. And I run into that with people where you have second marriages. They both bring assets to the marriage. They both want to leave assets to their own children. And they trust each other not to file for this elective share. But beyond that, you can really leave your assets to anyone you want. It's up to you.
Excuse me.
Yes?
Is this a general law, or is it just in North Carolina?
I'm just speaking of North Carolina law,
Okay.
except for taxes. That's
Okay.
federal law, but
That
yeah.
previous comment.
Probably other states have similar provisions, just so you don't leave a spouse
Mhm.
completely impoverished, but
Thank you.
this is just North Carolina. You can designate whether someone's going to receive the property outright, or whether your executor is gonna sell it and divide the proceeds among your heirs. And if you have property that you want to leave to a large group of people, and no one has any particular attachment to that property, think about having your executor sell it and divide the proceeds. Because particularly with land, if you get a large group of people owning land, it can get really messy. So this is just an opportunity to avoid that mess. If you have any minor children, or you're a guardian for your grandchildren, you can use the will to nominate a guardian when you die. It is up to the clerk of court whether they will approve that guardian, but barring some compelling reason not to, the clerk of court will generally follow your direction. You get to name the executor in your will, and this is just the person who does the work. It's really no great honor to be an executor, let me tell you. But they just do the work, they file documents with the court, they publish notice in the paper, they pay your creditors, they file your last taxes, they distribute your property. But because they have an opportunity possibly to steal your property, and because sometimes they're given discretion as to who gets what property and dividing up your personal property and things like that, you want someone with a little bit of integrity. But beyond that, they just do the work. And finally, in your will, you can create a trust. So you create a trust that when you die, that trust then becomes effective. And so that then really brings us to our next topic, which are trusts.
Could I make a comment?
Yeah.
One of the things I get a lot is in the pre-planning, like funeral, cremation, pre-planning side is people will say, well, I've written what I want in my will. Could you mention something about that?
Please do not make or edit your own will. Wills are very finicky. They're easy to mess up. You make your own will, you're gonna save a couple $100 by not seeing an attorney. And your estate will usually have to spend a whole lot more than that dealing with the issues that exist from the homemade will. So please don't do that. I'm not saying you have to come and see me, but please see an attorney to get your will done. I have some probate estates that just going on for years because homemade wills are not clear and the heirs are squabbling over the assets.
But what I was mentioning is the will the place to put your funeral plans? Because it's always been my experience that the will is read after the fact.
Yeah, there is a sequence. A healthcare power of attorney, that's body disposal. Generally what you should do is just let those who will be handling your affairs know your burial plans, separate and apart from your will. You can put it in the will, but he's right. Oftentimes you don't get around to reading the will until after the person is buried. So just let your people know if you have separate burial plans. I would generally also, along those lines, make a summary of what your assets and debts are to help your executor when they start administering your estate.
Excuse me.
Okay, yeah,
When you say separate from the burial plans, I mean, just write it on a notepad and give it to them, or?
yeah, I mean, it just so they know. I mean, that's really, you know, whoever's gonna be in charge of your burial plans, you just need to let them know what they are, and you know, if you've done a pre-planned plan, where is it? If you wanna be buried here, where, I mean, we can put it in your will, it should be binding, but again, they don't necessarily read it before you're buried. Okay, so trust. Unlike a will that deals with passage of property at one point in time, a trust is generally a vehicle to deal with the passage of property over time. You leave property in trust for the benefit of someone called the beneficiary, and it's managed by the trustee pursuant to the terms that you put in the trust document. So it's a good vehicle where you want to leave property to someone, but you don't want them to have unfettered access to that property. And so why might you want to do that? Particularly when someone cannot handle assets is when you should do that. You might have a minor child or grandchild, in which case you can leave property to them in trust for the trustee to then manage that property, and the trustee can use the property for the minor's health, education, maintenance, and support until the minor reaches a designated age, say 25, and then whatever is left goes to that minor. You might have someone who is a spendthrift, has a domineering spouse, has substance abuse problems, in which case, again, you can leave it to them in trust, and the trustee can be given discretion as to when property is distributed to them, so the trustee can sort of judge how they're doing and whether they need property. You know, we mentioned that you might have a second marriage and each spouse brought assets into their marriage, and you want to provide for your spouse, but when your spouse is gone, you want those assets to go to your own biological children. You can create a trust to do that. The trust can provide income to your spouse, principal to the extent your spouse needs it, and when your spouse dies, anything that's left goes to your own biological children or whoever you name. And so those are really good reasons to do trust. When you have someone who, for some reason, you want to limit their access to the trust property. Another reason along those same lines is a special needs trust where you have someone who gets government benefits. They're disabled, and giving them property outright can disrupt their government benefits. In which case you can specially design a trust so it won't disrupt their government benefits. Other reasons I see that people want to do trust that aren't always, I'm not always a fan of, are simply to avoid probate. To me, usually when you create a trust, you have to transfer all your assets to the trust. You have to manage the trust during your life, and after you're gone, that's as much trouble as probate is. So I just think a trust simply to avoid probate is usually not worth it. Some people want to maintain privacy, and yeah, if you get a trust and you put all your assets in your trust, that will be private. You know, that will not be a public document like probate documents will.
Can you define probate?
Probate is the process of settling your estate after you die. It's where you file documents with the court, and you pay your creditors, and you make sure that your taxes are filed, and then you just transfer the assets to your heirs.
Does a trust, if you have property in a trust, does it shelter you from any liability issues from that property?
Generally not, particularly if it's revocable. So you can't really put property in a trust, have access to that property, and escape liability. Yeah.
Are trust agreements part of a will or
They
separate
can be.
documents from a will?
Either way, you can do it either way. You can build it into your will, in which case it will only become effective when you die. Or you can create it during your life. You can do it both ways, it really just depends on the goals. One other reason I see people trying to do trust is Medicaid planning. They want to plan for Medicaid so that they don't have to use their assets for their own long-term care. These can get really messy. First, you have to transfer the assets to the trust at least 5 years before you need Medicaid, or you'll suffer a Medicaid penalty when you try to qualify for Medicaid. That you can have no longer any control over these assets. It has to be irrevocable. So I see people set these up and a few years go by and they want their assets back because they haven't needed Medicaid and they're tired of having their assets all controlled by the trustee. And if we undo the trust, then they've defeated the whole purpose of doing the trust. So again, you can do it for Medicaid planning. It really depends on the circumstances, but it's often messy and creates some problems. So the next topic are assets that pass by beneficiary designation or survivorship rights. And where we were talking about possibly doing a trust to avoid probate, if you simply have assets that pass by beneficiary designation or survivorship rights, that will avoid probate too. So that's a way to easily avoid probate for these assets without having to do the whole frustration of a trust.
Can you say that again?
If you have a bank account, a investment account that passes by beneficiary designation or transfer on death, that will avoid probate.
But if both people's names are on it, you don't have an issue?
Generally then, it's joint with rights of survivorship, if you have two people's names on it, and then the survivor owns those assets, and that goes outside of probate too. So both of those will avoid probate. And both of those will control over terms of your will. So if you have this investment account, and your will says this investment account goes to my son, but you have a beneficiary designation that leaves it to someone else, that beneficiary designation will control it.
What is not part of probate but disclosure required under joint ownership?
Yes, it's not part of probate property, so it's not subject to being controlled by the executor when you die, but you do disclose it as part of probate, so you do have to divulge the existence of the assets.
Yeah, if you have lifetime rights to
Mhm.
your home, does that protect you from the nursing home attaching that now, or is that?
Correct, that, under the current rules, lifetime rights in your home, or even a home, will not disqualify you for qualifying for Medicaid, and that won't be an asset that you have to get rid of or sell before you qualify.
So they can't attach your home? you know?
Correct,
Okay.
and that's then not something that's subject to attachment after
Oh,
the fact.
okay, thank you.
So with beneficiary designations, you're generally dealing with bank accounts, brokerage accounts, IRAs, and insurance. Already mentioned it's not part of probate, and it's not disclosed as part of the probate process. With accounts with joint with rights of survivorship, bank accounts, brokerage accounts, real estate, and vehicles. They are not part of probate, but you do have to disclose them as part of the probate process.
So what is, if real estate and bank accounts and investment accounts are not probate, what is part of probate?
You have to specifically designate those assets to be survivorship rights. Okay, so if you and your brother own a piece of real estate, and it doesn't say it's with rights of survivorship, you each own half. You die, you still own your half, and that's part of your probate.
Okay.
He dies, he owns his half. If it says rights of survivorship, when the first of you dies, it's all owned by the other. Then let's talk about durable powers of attorney.
That's it.
Yeah, go ahead.
How much does probate cost?
It really depends on the assets, and what you have to deal with. If someone's affairs are in order, it's not that expensive, and people can do it directly with the clerk of court. If someone's affairs are really messy, it can get expensive. If you have a taxable estate, so over $12 million right now, you're gonna have to file an estate tax return, and that will get expensive. But most people don't have that problem.
I have a question.
Yeah.
I've been in my home 25+ years, not mine, but my domestic partner, we have a child. Everything's in his name, he's excluded me. Am I entitled to
You're not
anything?
married?
Not with the certificate of marriage, that's with the.
Unless he has you with survivorship rights on accounts or
Right,
transfer on death. Yeah.
thank you.
What we talked about, where a spouse can, make a claim for an elective share, that is not available
It's
to
all
non-spouses.
into the Twiford.
Durable powers of attorney. These are important planning tools for lost the word, incapacity. If you lose capacity and you don't have a durable power of attorney, the only other option is a guardianship proceeding where someone files a proceeding with the court, has you declared incompetent, has a guardian appointed. The last guardianship proceeding I did was ran about $3,000. If you do a durable power of attorney, it might cost you $150. You name who will manage your assets. They have a duty to manage them for your benefit, but they do have access to your assets, so you want someone who's trustworthy.
Can you name more than one?
Pardon?
Can you name more than one?
Yeah, you can name them like successor, like first this one, if this person's not available, and this person, and third. You can name them, they both have to agree. You can name them two with either one having authority to act. You can make this effective only if you become incapacitated, or you can make it effective now. But again, it's a really good tool to plan for incapacity. It's cheap, and you get to select who will manage your affairs. If you have to rely on a guardianship, the clerk of court will select who will manage your affairs, and it may not be the person you would select. The first guardianship hearing I ever did, I was proposing a lady's sister get appointed as her guardian, and the clerk of court did not like her sister. And so the clerk of court looked around the room for someone else to serve as guardian, and who else was in the room? Me. I wound up being a guardian for someone I'd never even met. So anyway, it's up to the clerk of court. Do a durable power of attorney. You can choose that person.
Is it still true that, even if you have a power of attorney, if you want to, like, sell a particular piece of property, the power of attorney can't do that because unless you specifically state that?
You can tailor the powers of attorney more broadly or more narrowly to include a general power to sell real estate or not. So you can really just tailor it accordingly. And you can just do a power of attorney for only one purpose, which is to sell this piece of real estate if you want. And the final topic is a healthcare power of attorney. And this is a device where you select a person who can make healthcare decisions for you if you cannot do so. This can extend to include what's referred to as a living will, where they can make the decision to refuse life continuing care or unplug you from life continuing care if you're basically permanently in a coma, if you have severe dementia and some other life-threatening issue, or if you have a life-threatening condition otherwise. So if you have a terminal condition and it ends near, they can go ahead and discontinue care at that point. If you do not have a healthcare power of attorney, the statutes provide one for you, but the statutes provide a sequence of people that may not be the people who you would have making your healthcare decisions. So I recommend a healthcare power of attorney too. And so those are really the main estate planning documents: wills, trusts, assets that pass by beneficiary designation or survivorship rights, healthcare powers of attorney, and durable powers of attorney. Questions? Yeah.
You mentioned before, no, not you, sorry, someone mentioned before, lifetime rights to the property. What is that?
With real estate, you can transfer that real estate to someone, but retain the right during your life to continue living in that property. And that's what you're referring to. You can also transfer real estate to someone and give the life right to this person, and the remainder once their life is gone, to this other person. And I see people do that in wills. I want this person to have the right to live in that during their life, but when they're gone, it goes to this other person.
Thank you.
I have a question. I'm associated with several different people that have passed, their families having to pay a lot of money for them. And before they passed, they had to go into a living facility. How do you avoid that in the event that if I were to have to go into a living facility, to avoid my children not be burdened with such an expense?
There are ways to help with that. They're probably much more involved than this talk, but we can talk about it briefly. A trust is one mechanism. You know, I touched on that briefly. You have to transfer your assets to the trust 5 years before you need Medicaid, and then understand you no longer have access to that property. There's some assets or some ways you can change ownership of your assets, like let your children buy into a partial interest in your real estate. That will take that real estate off of the limits off of the reach of Medicaid. That's under the current laws, and they can always change the laws, but your child could purchase a 1% interest in your house, and then that would not be then subject to Medicaid recovery, and that would not disqualify you.
That was my primary concern.
Yeah.
Does that still have to be in effect 5 years ahead of the need?
Not if they pay fair consideration for that 1%, which would be 1% of the tax value.
Okay.
But again, that's under the current rules. Medicaid can change those rules. You can still keep your home and qualify for Medicaid, it's just they will come back. If you haven't done any planning, they can come back when you die and file a lien against your estate.
That's what I want to avoid.
You want to avoid that. Yeah. Then possibly joint ownership with a child with rights of survivorship might be a mechanism.
Is there a time limit on that?
Not if they pay fair
Once
consideration.
you set it up, it's
Yeah,
effective
unless
immediately.
they change the rules, yeah. It's not guaranteed.
I got you.
Another mechanism is you can retain a life estate in the house, like we just talked about, and transfer the remainder to them. If they don't pay a fair value up for that, though, you still have that 5-year period to look back on.
What if you gave a percentage of a property to one of your children under gift tax law versus monetary compensation? What would the differences be?
None. In terms of what you've given that child, whether it's a piece of real estate or money, it's the fair market value of what you gave them. So that's how that's valued. Gift taxes, that's part of your, that $12 million we talked about. So if you give property away during your life, that will just be subtracted off that 12 million, then that's a little bit less you can give of your 12 million that you can give away.
Well, I think if I heard correctly, he was asking if he wanted to sell his children on 1% of his property, but instead of taking money, just saying, I'm gonna give this as, let's just say it was, $5,000.
No, you need to sell it.
As a gift, you have to actually
Yeah.
sell it and not use it as
Yeah.
the gift thing, okay.
Under federal tax laws, you can give up to, I believe, $17,000 to people each year,
Right.
tax-free. That is separate from Medicaid. They are separate rules. Medicaid, you don't have that. You give away property for less than fair market value, and that can subject to you to Medicaid recovery or a transfer penalty before you qualify for Medicaid.
Not to get into weeds too much, but if you do sell a percentage, the deeds have to be modified to reflect that?
Yes, you have to do that with the deed.
Okay.
After I had paid out probably all of our parents' life savings from nursing home, they had like $5,000 left. And when I went to social services, I said, well, they have lifetime rights to their home. And they wouldn't give, the answer was, we'll discuss that when the time comes. But you're saying that they can't go after their home, they can't attach their home.
They don't have a right when they die. They no longer have any rights to that asset. So Medicaid, there's nothing to attach as part of the estate recovery.
No, I mean after their money was all gone,
Okay.
and they had to get Medicaid.
Under Medicaid rules, property where you just have a life interest in or a life estate in that property is not subject, it's not an asset that's considered. So they may have just been hoodooing you. I
So
mean,
they were just avoiding my,
yeah,
instead of saying, no, we're not going, we can't attach that,
right.
but we can give them Medicaid.
Right, and they won't attach it while you're alive. What they'll just make you do is liquidate the asset and spend the asset. But assets where you just have a life estate is not part of what they'll consider.
Okay, they just weren't, they weren't. Yeah.
Yeah.
And I just wanted to make a comment.
Yeah.
One of the things that I've ran into is Medicaid, you can only have $2,000 in assets to your name. And a lot of times, families, if you have a whole life insurance policy, it is considered an asset because it does have cash value.
Yeah, I think it's beyond some threshold, and I think it's $6,000. But if you have that asset, that they'll want you to cash that in and use those funds for your care before they will pay for your care. Yeah.
Would I be able to have something witnessed and notarized today?
You can come over, you can come over to our
I'm
office
already
after the meeting. I mean, I don't have a notary staff with me, but
I have a notary stamp.
Yeah, okay.
Thank you.
There you go. Yep.
Okay, thanks.
If someone's given lifetime rights, who maintains the property?
The life tenant has the duty to maintain the property for normal maintenance. If you have substantial repairs, that may fall on both people. But the problem is the life tenant doesn't have much incentive to maintain the property.
Right.
And so that's always a tension you run into, because they're not gonna spend their money fixing up a piece of property they can't sell and they can't leave to their own children. So that's always a problem.
If you have substantial real estate holdings in joint ownership with others, is that subject to Medicaid?
It depends on the nature of the joint ownership. If it is, if you jointly own it, yes and no. If you jointly own it as tenants in common, it is not subject to Medicaid claims. If you jointly own it as joint tenants, it can be. So it depends. You have to look at the deed.
Well, let's say that the joint ownership by the others is a general warranty deed versus tenants in common.
The deed, the general warranty deeds could expressly be one way or the other. So we would have to look at the deed. Yeah.
What's the best way to protect, like say your spouse would have to go to a nursing home or something to protect your assets so you don't lose everything? before Medicaid?
Medicaid looks at spouses as one joint unit. So if all the assets are in your name, Medicaid won't care. They will look at your assets or part of his assets and vice versa. So, the first person qualifying is usually not an issue. If you own a home and you're living in the home, your spouse goes to Medicaid, your home's an excluded asset because you're living in it. Medicaid will also set aside half of your other assets up to about $126,000 for your use. And I'm just using you because you asked the question. And then Medicaid also will, in terms of income coming in, if your name's on the check, it's yours. If that does not provide sufficient income in terms of, they may also have a spousal resource allowance that provides for you. So that they won't leave you destitute, but, they will, beyond those, they will still make you use the assets.
So then otherwise you need to use one of these other vehicles to protect.
Yeah, and you can, with a spouse, you can actually also purchase a specially designed annuity that can pay out to you, the surviving spouse. There are a few other measures if you have a married couple and you're considering Medicaid.
Next question.
Mhm.
What's your experience with long-term care, which has gotten certainly harder to get by now, being very affordable, but if you've got something in place, but these companies are, I don't know, falling by the wayside.
It's because it's expensive. Yeah, I don't have a whole lot of insights on that. I just don't have a lot of experience with that.
I have a question on just a generic will. Say you have, for example, 2 children.
Mhm.
One passes away, you haven't updated your will. What's the default of the will at that time?
The default, the statute provides a default, which is those assets would go to that child's children
Okay,
and grandchildren. So they would go to that child's descendants.
okay.
If that child left no descendants, then it would go to his or her siblings. So, yeah, and then it goes back up the tree and down to aunts and uncles, yeah. Any other questions? Okay, well, you have my contact information, my card. If you have questions, feel free to call. I'll spend a few minutes talking to you.
And I wanna ask a favor. In the folder, there is a survey. Would you please take a moment and fill that out, and you can just leave it right on the table and I'll collect them after you leave. But under additional comments, if you would maybe, we want to do more and more of these, and I like the idea that more people show up when we have an attorney, so, maybe some suggestions of topics and things that you're interested in learning more about. And, we thank you for coming.
Question.
Yeah.
My wife ran into an issue where she was a power of attorney for an aunt in Florida. And because she didn't live in Florida, she couldn't do it. Was that,
Did the bank, was the bank refusing to?
no, I don't know who refused to do it.
No, it was actually our accountant down there, he told us that I wasn't allowed to because of the fact I wasn't a resident of Florida.
I'm not licensed in Florida, I can't speak to Florida laws, but my impression is that all states recognize powers of attorney executed pursuant to the laws of other states. And certainly we do in North Carolina.
Yeah, I didn't quite understand it, but I didn't thought, well, I'm not gonna trip down if I'm not supposed to be there, you know?
But I just don't think that's right.
Okay.
But again, you have my contact information, feel free to contact me, I'll spend a few minutes talking to you. Thank you, appreciate it. Thank you.
And
Thanks.
thank you. And again, thank y'all for coming out. And also just as important is pre-planning your services, your funerals, so keep that in mind.
Okay, school's out.
This is recess or? Okay. Okay. Gotcha.
You have a good day. You have a good day.
You too, thank you.
give a distant view.
funeral pre-planners, we're gonna.
Yeah, can do that. We live in the city, Eastern North Carolina has a lot of people that move. And most of my family's in the West, so, matter of fact, I'm a licensed director. Pretty much all of our staff.
My eldest is 44, just saw him and he's gonna take care of everything.
See your grandson right now.
You won't be seeing him too much longer.
Really?
No, he's moving over to, Sago.
Okay.
Yeah.
Yeah, see over there, and, we usually go about, almost every Monday, and so we get to see him there. So.
Yeah, yeah. We enjoy going there too. Of course, he enjoys having us go there too. Yeah. He always makes out very well.
I understand.
Yeah.
My granddaughter was over in, Cyprus, so she did a bit on the night shift over there.
Yeah.
I guess that's what grandparents are for.
Yeah, that's right. What else we got to do with it?
That's right.
I knew that all I had to do was go back there. They were initially.
Yeah. They'd be good. Cut out the middleman.
That's right.
And also, one of the things, right with, stop this.